Hi there, Ariel Overstreet Adkins, attorney and founder of Bluebird Law in Billings, Montana, here today to answer a frequently asked question. That question is, what happens if I die without a will? If you pass away without a will or a trust, state law is going to fill in the gaps. State law will dictate who gets what if you haven't clarified in a will or trust who you want your beneficiaries or heirs to be. State law tends to follow exactly what you think it would do. First to a surviving spouse, if there is one. And if no surviving spouse, we look down towards the children or grandchildren. If there are no children or grandchildren, then we go up a level to the parents. And if they are not living, then we come back down to the parents' children. So you and your siblings, and then on down to nieces, nephews, and so forth, until someone is found who is alive and can inherit your estate. But that sounds really simple. There are some really complicated things under the default statutes. For instance, if you have a blended family where either you or your spouse have children from a previous relationship, that can really complicate things under the default statutes. Another really interesting situation that surprises a lot of people is if you are married but don't have any children. If you die without a will in that scenario, your parents might be entitled to inherit part of your estate above a certain dollar amount after your spouse. And so that's really an interesting thing that people like to know about. So even though Montana law does fill in the gaps for us to make sure that there's someone in your family tree to receive your estate, it really might be different than what you want to have happen. And the default statutes don't clarify who is to be in charge of assets that are left to a minor or to an incapacitated beneficiary. So having a will or trust will allow you to ensure that your estate passes to who you want it to and how you want it to, which might include certain ages or stages for minor children. You can also designate the person you want to be in charge of administering your estate. Perhaps most importantly, for parents of minor children, you can nominate a guardian or conservator so you can make sure your kids are taken into the care of someone you trust. If you're interested in finding out more about what might happen to your assets under Montana's default statutes, if you were to die without a will or trust, that is a major part of our 2-hour family wealth planning session. I invite you to schedule a free 15-minute call with me to discuss whether a family wealth planning session might be right for you. We'll look forward to talking to you. Have a great rest of your day and see you soon.